Welcome to the weekly press briefing of the Kosovo Specialist Chambers, where we aim to provide journalists with an update on the latest developments at the courts and the opportunity to ask questions. On the 4th and the 9th of July, in the case of Hashim Thaci, Kadri Veseli, Recep Salimi, and Jakub Krasniqi, the KSC president assigned appeals panels to decide on 5 separate appeals, which all relate to how the trial panel interpreted the application of Rule 149, which deals with the evidence of expert witnesses. This followed earlier decisions by the trial panel on the 1st and the 7th of July, granting in part defense teams' requests to appeal these matters. The trial panel found that the resolution of this issue may impact the fairness of the proceedings and could also affect the way in which the trial panel should approach such evidence when assessing its weight and its probative value. All 5 appeals panels consist of judges Michelle Picard, Kai Ambos, and Nina Jorgensen. In the same case, on the 3rd of July, the trial panel denied the admission of 3 expert reports requested by Victims' Counsel, as Victims' Counsel did not foresee calling the report's authors to testify. Under the rules, the defense must have the opportunity to challenge an author of an expert report in court, unless the defense does not object to the admission of such a report without the relevant expert witness's testimony in court. The trial panel deferred its decision on 3 additional reports until after the testimony of the Victims' Counsel's expert witnesses who have authored or co-authored the relevant reports. In its decision, the trial panel also approved the Victims' Counsel's request for 2 expert witnesses to testify together and scheduled their testimony to begin on the 16th of July. Noting that as a result of the limited nature of the defense request for dismissal of charges, the trial proceedings are expected to advance to the next stage. On the 4th of July, Victims' Counsel notified the trial panel that they estimate that the testimony of the 2 expert witnesses will take 2 hours, after which the prosecution has indicated that it will need 2 hours for cross-examination, and the defense has estimated that it will need 5 hours for cross-examination. On the 9th of July, the trial panel admitted into evidence the statements and evidence of a number of victims upon the request of Victims' Counsel, as they relate to the harm the victims suffered. The trial panel also denied the admission of some associated exhibits proposed by Victims' Counsel, because these exhibits had not been discussed in detail during court testimony. In the same case, a decision from the 1st of May by the trial panel admitting the written evidence of a witness pursuant to Rule 155 was made public earlier this week. This rule allows for the admission of a written statement or transcript by a person who is unavailable to testify in person by reason of a physical or mental impairment or other compelling reason, if certain conditions are satisfied. In their decision, the judges noted that because the defense will not be able to cross-examine the witness, the rules require that the witness's evidence cannot be relied upon by the trial panel to a sole or to a decisive extent. The trial panel emphasized that it would consider this, along with any other factors raised by the parties, when determining the ultimate weight, if any, to place on the witness's evidence. The trial panel also emphasized that this witness is a crime-based witness whose evidence does not go to proof of the acts and conduct of the accused as charged in the indictment. In the Salih Mustafa case, on the 9th of July, the Specialist Chamber of the Constitutional Court dismissed the most recent referral by Salih Mustafa in relation to his sentence, in which the defense had alleged that the sentence was disproportionate. The Constitutional Court panel explained in its reasoning that since the applicant neither challenged the proportionality of the punishment prescribed by law for the offense, nor advanced any arguments indicating that the sentence imposed on him was grossly disproportionate to the gravity of the offense, the judges found that the referral did not reveal any appearance of a violation of the applicant's constitutional rights. On this basis, the Constitutional Court dismissed the referral as inadmissible. As a reminder, Mr. Mustafa's original sentence of 26 years imprisonment was reduced by the appeals panel to 22 years of imprisonment in December 2023, and further reduced by the appeals chamber to 15 years in September 2024, following guidance from the Supreme Court chamber on sentencing. In the same case, and in the interests of the publicity of proceedings, the single judge overseeing the implementation of the reparation order has ordered the registrar to file public redacted versions of a number of confidential documents, and indicated that public versions of related decisions will also be issued. Mr. Mustafa was convicted of the war crimes of arbitrary detention, torture, and murder in 2022, and was ordered to pay an overall sum of 207,000 euros as compensation for the harm inflicted on the victims of the crimes for which he was convicted. The reparations order has so far been partially implemented, and the participating victims in the case have received a percentage of the reparations ordered to them, with the exception of one victim who did not wish to receive reparations. In the Pietrashala case, the appeals panel is scheduled to pronounce its judgment next Monday, the 14th of July, starting at 11:30 in the morning. The hearing will be public and can be followed in Albanian, English, or Serbian through the streaming page of the KSC website with a 10-minute delay, or from the public gallery at the premises of the court.